Hello everyone, I am Monalisha Padi. I am a legal intern at Lexis and Company. I am a third year student of BBA LLB at Bharati Vidyapeeth New Law College, Pune. And today's topic is non-consummation, a ground to annul marriage. In today's society, you will find many couples desperate to annul their marriage on the basis that it had not been consummated. Britney Spears hit the headlines a few years ago for annulling her Vegas wedding on the same ground. Consummation has been a crucial part of marriage. In many countries across the globe, wedding rituals to be an important part of the wedding ceremony. The families of newly married couples would take steps to ensure that the marriage had been consummated. Part of this process was to prove that the bride had been a virgin before the wedding. The bed sheets would be taken away the day after the wedding night to be examined for the traces of blood, the ultimate sign of virginity and its loss. This tradition back thousands of years and was particularly important to royal weddings. What is consummation? Technically, consummation of a marriage requires ordinary and complete rather than partial and imperfect sexual intercourse. Incapacity must be physical or psychological and must be permanent and incurable. The fact that the parties may had successful intercourse before the marriage is irrelevant if the incapacity existed at the time of marriage. So, by consummation, we mean capacity to do sexual intercourse. It has nothing to do with ability to procreate. So, marriage is very well consummated even though the person is sterile or infertile or the wife has no uterus. Grounds of no consummation. There are two possible situations for non consummation of marriage. First is impotency. It is a ground for making a marriage voidable under Section 12 of Hindu Marriage Act, meaning that on this ground you can get your marriage declared void by the court, and it has been judicially recognized as a part of cruelty under Section 13 of Hindu Marriage Act. Second is persistent refusal to have marital intercourse that amounts to cruelty. Impotency must exist at the time of consummation of marriage. By impotency, we mean a practical impossibility of consummation of marriage, that is, inability to perform or permit permanence of complete act of sexual intercourse. Thus, partial or imperfect, difficult, and painful intercourse amounts to impotency. However, sexual intercourse which is incomplete occasionally does not amount to impotency. Impotency is usually either physical or mental. The latter includes emotional, psychological, or moral repugnance or aversion to the sexual act. If impotency can be cured by medical treatment or surgery, it would not amount to impotency unless the person refuses to undergo treatment. There is difference between impotency and ability to procreate children. Law takes into account only impotency. In Rita versus Balikishan Nijavan, Delhi High Court said that a liberal interpretation be given to the term impotence under Section 12, Clause 1 of Hindu Marriage Act 1955 and eventually held that a sexless marriage is physical and mental cruelty and thus is a valid ground for seeking divorce. Court held that if either of the parties to a marriage being of good health and physical capacity refuses to have sexual intercourse, the same would amount to cruelty entitling the other parties to a decree. It does not mean that denial is due to sexual weakness or because of any willful refusal by a spouse. Either way, it will result in frustration and misery to the other spouse. Here, it is not necessary to prove the culpability of erring spouse to hold him guilty of cruelty. What has to be found in each case is whether the act is such which the complaining party should not be asked to endure. A single act or isolated acts of refusal to indulge intercourse does not amount to cruelty. If the person on most of the occasions is fulfilling his or marital obligation, that is sexual intercourse, then it's perfectly okay. In Sheldon versus Sheldon, a decree was granted to the wife on finding that the husband persistent refusal of sexual intercourse over a long period without excuse caused a grave injury to the wife's health and amounted to cruelty on his part. Lord Denning observed that the categories of cruelty are not closed. The persistent refusal of sexual intercourse is not excluded. The legal conception of cruelty is generally described as conduct of such a character as to have caused danger of life, limb, or health, or as to give rise to a reasonable apprehension of such danger. Intention is not essential for cruelty as a matrimonial offense. If there is evidence to prove that the husband was never been able to have proper sexual intercourse and always left the life unsatisfied and miserable, though there is no suggestion that he deliberately or wantonly acted in such a manner as not to give sexual satisfaction to his wife, still has committed cruelty. That's all for the topic. Thank you. Please comment and like on the video.